Assalamualaikum and selamat sejahtera to Sewasfi. My name is Farisha Fatihah Binti Mohamad Fuad. I am from DPA30083A and today I will be present about topic 7, which is winding up. Based on the question 1 given, the issue is whether there are breach of duty made by the directors or not. Section 213, subsection 2 state that a director of a company shall exercise reasonable care, skills, and diligence with subsection A, the knowledge, skills, and experience which may reasonably be expected of a director having the same responsibility, and subsection B, any additional knowledge, skills, and experience which the director in fact has. Section 213, subsection 3 also stated that a director who contravenes this section commits an offence and shall, on conviction, be liable to imprisonment for a term not exceeding 5 years or to be fined not exceeding 3 million ringgit Malaysia or to both. What is reasonable? In determining what is reasonable, the court will assess a director's conduct, taking into account all of the circumstances that at the time. There is no single standard of care and diligence which applies to all directors. Section 443 also stated that declaration of solvency is required before a company may commence a member's voluntary winding up. Majority of directors should ensure the following. The first one is make a written declaration to prove the inquiry of the company's affair. The second one is to form an opinion that the company is solvent, which is the company has the capability to settle its debt and the liability within the 12 months of periods after the winding up. Section 444 also stated that a winding up in the case of which a director's declaration has been met is a member's voluntary winding up, and a winding up in the case of which such declaration has not been met is a creditor's voluntary winding up. In accordance with Section 447, subsection 1, if the liquidator is of the opinion that the company will not be able to settle its debt and liability within the period of 12 months, he or she shall forthwith summon a meeting of the creditors and lay the statement of assets and liability before the company before the meeting. There are the cases that I found that are quite similar to the cases given in the question 1. The name of the case is LRH Services Limited against True and Others 2018. Creditors sued 3 of its directors as the directors had formulated and implemented a group reorganization whereby the company's share capital had been reduced and a dividend of 21 million paid to the company's sole shareholder. UK company law required that prior to the capital reduction, the directors should make a declaration of solvency that each director had formed the opinion that there was no ground on which the company could be found to be unable to pay its debt, and if it was intended to commence its winding up within 12 months, the company should be able to pay its debt in full within 12 months of the winding up. The decision is the reorganization had been implemented in a way that made the company insolvency is unavoidable. So, the directors breached their duty to act in the best interest of the company and duty of reasonable care, which by that had become a duty to act in the best interest of the creditors. Based on the case of LRH Services Limited against True and Others 2018, the liquidator of LRH brought a claim against 3 former LRH directors. Directors had formulated and breached their duty by reducing the LRH share capital. In applying the section to the situation given in the question 1, the declaration of solvency made by the directors of Tradis Sendiri and Berhad had been duly negligently prepared, causing a breach of duty of the directors in accordance with Section 213, subsection 2 of the Companies Act 2016. accordance with Section 213, Subsection 3 of the Companies Act 2016, the directors may liable for the breach of duty and may face an imprisonment for a term not exceeding 5 years or fine not exceeding 3 million ringgit or to both. Sarah also needs to summon a meeting of the creditors if she is of opinion that Radek Sendirian Berhad have several liabilities to creditors which are unable to be settled within a 12-month period or insolvent with the accordance of Section 447 of the Companies Act 2016. Section 448 of the Companies Act 2016 also stated that conversion to creditors voluntary winding up is based on if the liquidator is of the opinion that the company will not be able to settle its debt in full within the period stated in the declaration of solvency. Liquidator shall summon a meeting of creditors. At the meeting, creditors may appoint the liquidator appointed by the company or appoint any other person to be liquidator. Once the meeting of creditors is held, the winding up shall proceed as if the winding up were creditors' voluntary winding up. In conclusion, while the summary approval procedure is valuable, efficient, and cost-effective way of permitting a restricted activity by a company, directors should inform themselves fully and carefully when making the declaration of solvency. Where a company director makes such a declaration without having reasonable grounds for the opinion that expresses, the court may declare that the director is personally liable for all the debts or other liability of the company.
Issue for this question is whether Sarah can apply for a winding up by the court or not. Next is winding up is a process in which the existence of a company is brought to an end, in which assets of a company are collected and realized. The proceeds collected are used to discharge the company's debt and liabilities, and the remaining balance, if any, will be distributed among the contribution according to their entitlement. Under Section 464, Subsection 1, Subsection A until Subsection H, state the parties who have locus standi, which is the company, any creditor, a contributory or personal representative or trustee or director general of insolvency. Next is the liquidator, the minister, the licensed institution, the operator of designated payment system. Next is the register, the member institution under the Malaysia Deposit Insurance Corporation Act 2011. According to Section 465, Subsection 1, Subsection A until Subsection L, A. The company passed a special resolution that the company is to be wound up by the court. B. The company default in lodging the statutory declaration. C. The company does not commence business within a year from the date of incorporation, or the business has been suspended for a whole year. D. There is no member in the company. E. The inability of the company to pay its debt as discussed further in the Section 466, Subsection 1. F. The directors act for their own interests. G. The company expires as being stated in the Constitution. H. The court is the relevant case for this situation is Coca-Cola Refreshment Malaysia Sdn Bhd against Legend Capital Sdn Bhd. The plaintiff, Coca-Cola Refreshment Malaysia Sdn Bhd, is a creditor of the company. Legend Capital Sdn Bhd is a company. Coca-Cola was owed a debt of approximately 1.4 million ringgit Malaysia. On 16 July 2020, the company commenced a creditor voluntary winding up and with an interim liquidator appointed. As part of the creditors' voluntary winding up, the members' meeting was held and where the members had resolved for the winding up of the company. Law for this case is Section 450 state that the company shall and creditors may appoint a liquidator. The choice of the creditors, tax proceedings, and application must be submitted to court for confirmation of the appointment. Section 450, Subsection 6, state that on the appointment of the liquidator, the powers of function of the director shall cease except as sanctioned by the Committee of Inspection or Creditors. In applying to Section 464, Subsection 1, Subsection D, liquidator is one of the parties who have locus standi. To apply for the winding, Sarah should have the locus standi. In applying to Section 465, Subsection 1, Subsection F, state that the directors have acted in affairs of the company in the directors' own interest of the members as a whole or act in any other manner which appears to be unfair or unjust to members. The conclusion is yes, because Sarah can apply the winding up by the court because Sarah have the locus standi. Sarah also interim liquidator.
My name is Alya Syahira and I will explain about compulsory winding up by the court. The issue is whether AMA can petition compulsory winding up order by court or not. And the law is, according to Section 432, Subsection 1, there are two types of winding up, which are voluntary winding up and compulsory winding up. A winding up by the court is known as a compulsory winding up. It begins with the presentation of a petition in the court. In compulsory winding up, a creditor asks the High Court to wind up the affairs of an insolvent limited company. This legal process ends with the company's removal from the company's house register, effectively ceasing to exist. Once the order has been made, the High Court appoints the official receiver as liquidator. The official receiver works for the insolvency service and finds out how and why an individual became bankrupt or a company went into compulsory liquidation. There are 9 parties who have locus standi in the petition of a compulsory winding up under Section 464, Subsection 1, Subsection A until Subsection I, which is the company, any creditor, a contributory, the liquidator, the minister, the licensed institution, the operator of designated payment system, the registrar, and the last one is the member institution under the Malaysia Deposit Insurance Corporation Act 2011. There are 12 grounds listed as the circumstance for a compulsory winding up as according to the Section 465, Subsection 1. Subsection A. The company has by special resolution resolved that the company is to be wound up by the court. In Subsection B, the company defaults in lodging the statutory declaration under Subsection 190, Subsection 3. Subsection C. The company does not commence business within a year from its incorporation or suspends its business for a whole year. And Subsection D. The company has no member. Subsection E. The company is unable to pay its debt. Subsection F. The director have acted in the affairs of the company in the director's own interest rather than in the interest of the members as a whole or acted in any other manner which appears to be unfair or unjust to members. In Subsection G, when the period, if any, fixed for the duration of the company by the Constitution expires, or the event, if any, occurs on the occurrence of which the Constitution provides that the company is to be dissolved. Subsection H. The court is the opinion that it is just and equitable that the company be wound up. Subsection I. The company has held a license under the Financial Services Act 2013 and that the license has been revoked or surrendered. Subsection J. The company has carried on a licensed business without being duly licensed, or the company has accepted, received, or taken deposits in Malaysia in contravention of the Financial Services Act 2013 or the Islamic Financial Services Act 2013. Subsection K. The company is being used for unlawful purposes or any purpose prejudicial to or incompatible with peace, welfare, security, public interest, public order, good order or morality in Malaysia. Subsection L. The Minister has made a declaration under Section 590. Cases that are related with the scenario is Ibrahimi against Westbourne Galleries Limited and others. So, the company consists of two shareholders, Nazar and Ibrahimi, where both of them are shareholders and directors of the company. They were not paid any dividend but received wages for their services. Later, Nazar's son joined the company as shareholder and director, and now two of them control the company. Then, they terminate Ibrahim, which caused him loss of income. Ibrahim made a petition to wind up the company. The decision that we can take from the case is it was held that general word should remain general and not be reduced to the sum of particular instance, and for the words just and equitable, they should not be interpreted so as only to include matters ejusdem generis as the preceding clauses of the section. So, in applied case Ibrahimi against Westbourne Galleries Limited and others, to the scenario given, this case was influenced corporate governance by highlighting the importance of considering the interests of all shareholders, not just the majority, in the management and operation of a company. It underscores the principle that while majority shareholders have the right to govern the company, this power should not be exercised in a manner that is unjust or inequitable to minority shareholders. Based on the scenario given, Amar was lost his source of income because of Reza and Diana had passed a resolution to terminate him. Then, Amar felt disappointment and had petitioned and granted a compulsory winding up order by court. So, the conclusion of this case is, yes, the respondent company Westbourne Galleries Limited should be wound up by the court because the court's willingness to consider equitable principles and individual rights when deciding whether to order the winding up of a company, particularly in the context of closely held companies with quasi-partnership characteristics. That's all from me. Thank you.
For issue is question 2. For issue 2 is whether Azlan had discharged his right duties or not. Below is Section 456 of the Companies Act 2016. The liquidator may, in the case of a member's voluntary winding up with the approval of a special resolution of the company, and the case of a creditor's voluntary winding up with the approval of the court or the committee of inspection, exercise any of the powers given to a liquidator under the 12th schedule in a winding up by the court. Next, the liquidator may exercise any of the other powers by this act given to the liquidator in a winding up by the court. Next, the liquidator may exercise the power of the court under this act of settling a list of contributories, and the list of contributories shall be prima facie evidence of the liabilities of the person named in the list as contributories. The liquidator may exercise the power of the court of making calls or summon general meeting of the company for the purpose of obtaining the sanction of the company by special resolution in respect of any matter or for any other purpose as the liquidator thinks fit. Next, the liquidator may pay the debt of the company and adjust the right of the contribution among themselves. Lastly is, when several liquidators are appointed, any power given by this act may be exercised by one or more of the liquidators as is determined at the time of the appointment, or in the absence of such determination by at least two of the liquidators. The relevant case for this situation is Yo and Kiat and 238 against Hong Leong Bank Berhad and Anor 2016. The fact is, the appellant were the purchasers in a project known as Genting Valley Countryside Living Resort developed by the second respondent. The second respondent, as the owner of 4 plots of land on which the project would be developed, had charged the lands to Hong Leong Finance Berhad, the first respondent. The project was abandoned sometime in 2004. And consequently, winding up petition was presented by the first respondent against the second respondent on 20 June 2006. On 20 January 2007, an order for the winding up of the first respondent was made, and Ler Cheng Chi and Lam Tak Cheong, the liquidators, were appointed as liquidators. There were attempts made by the appellant and the liquidators for the revival of the project between 2007 and 2014, but they failed. In July 2014, the appellant filed an application for the removal of the liquidators, but the said application was dismissed by the trial judge. Hence, this appeal. The main issue in this appeal was whether the finding of fact by the land trial judge that the appellant had failed to discharge the burden of proving that there was just cause of removal of the liquidators was justified. The health for this case is, on the totality of the evidence, the land trial judge did not appear to have addressed the grievance of the appellant in the context of the delay occasioned by the liquidators. The liquidators had deviated from their primary duty, which was to wound up the business of the second respondent. Instead, they went into the business of attempting to revive the abandoned project over a period of 8 years. Consequently, after the lapse of 8 years, the liquidators still had not been able to complete the compulsory liquidation. The liquidators had not acted with due dispatch or with sufficient vigor expected of a court-appointed liquidator in compulsory winding up. The lapse of 8 years in compulsory winding up was inordinate and unreasonable. Thus, it was in the interest of the liquidation and all those who were interested in the company being liquidated that the liquidators be forthwith removed and a new liquidators be appointed. In applying to the case of Yo and Kiat and 238 ours against Hong Leo Ben Berhad and Anors, in the scenario given Ler Cheng Chi and Lam Tak Cheong, this is because Azlan did not know the right ranking of. Meanwhile, the power of liquidator in the voluntary winding up can be summarized in the 11th schedule under section 456. The conclusion is no, Azlan did not discharge his right duties or as he failed to follow the ranking of funds to be distributed.